A young boy was badly injured in Michigan by a riding lawnmower purchased from a store headquartered in Illinois. His mother's subsequent legal battle on her own and his behalf, Townsend versus Sears, Roebuck and Company, featured a question about which state's law governed the liability and damages issues. James and Michelle Townsend lived in Michigan with their young son Jacob and 3 other children. One day, James was operating a Sears-brand riding lawnmower on the Townsends' nearly 2-acre property when the lawnmower got stuck against a railroad tie planter. James looked over his shoulder and reversed, unable to see that Jacob was standing in the way. One of Jacob's legs was badly injured in the accident, and his foot was later amputated. James had purchased the lawnmower from a local Sears store in Michigan, but the store was headquartered in Illinois, where it also made many of its design and business-related decisions. Michelle filed a personal injury lawsuit in Illinois state court on behalf of herself and Jacob, accusing Sears of strict products liability and negligence based on the lawnmower's defective design and the store's failure to warn. During a trial, a question arose about which state's law governed the substantive liability and damages issues, Illinois or Michigan. This question was important because there were 3 big differences between Illinois and Michigan law that were going to affect the outcome of the case. First, Illinois imposed a strict liability standard for product design defects, whereas Michigan imposed a pure negligence standard. Second, Illinois didn't place any cap or upper limit on compensatory damages for non-economic injuries, whereas Michigan did. And third, Illinois allowed for punitive damages in appropriate cases, whereas Michigan didn't. Unsurprisingly, Michelle preferred Illinois law, and Sears preferred Michigan law. The trial court ultimately concluded that Illinois law governed the liability and damages issues, and the Intermediate Appellate Court agreed. Sears appealed once more, this time to the Illinois Supreme Court.